I just wanted you to make a comment on what I'm going to say, just briefly. Here where we are, it's a human rights court with its own procedures. And instruments. I could say we are self-contained. And from your submissions, I heard you are encouraging the court to look elsewhere to the procedures of other courts. And I've said we are self-contained. Is it really necessary? During submissions, I heard Dr. Owiso say that the claim is in respect of people's rights and not states' rights, whatever that means. I also heard Counsel Aboje, hope I got it right, saying that these are violations of rights of nationals of DRC by Rwanda that form the subject matter of this application. How do you reconcile those statements with the position which you took during the submissions, that this is a matter purely on security, peace, sovereignty, and territorial integrity, and not necessarily human rights? I would just want to hear a comment from you on that one as well. A direct one, a more direct one? Is the case which you referred to that was lodged with the East African Court of Justice between the parties, is it a bar to this one? You referred to so many principles there. Res judicata was discussed. I had known this in idem lis pendens and so on. Then I also had Counsel Aboje saying that it could be considered as a local remedy to be exhausted before coming here. So is it a bar? Finally, and I really want you to understand me on this one, I'm glad this is an African court and it's Africans that are here litigating. When you see a frog jumping around under some scorching sun and the ground is hot, then you must know that wherever it's coming from, things may not be very good. You've come around looking for justice. By the time you came here, things must have not been good out there. And there are many ways through which we can give you justice here. The respondents especially referred to those other mechanisms in the Constitutive Act, plus the Great Lakes Pact of Amicable Settlements, and so on. I would like to draw your attention to Rule 64, Sub-Rule 2 of this court. And would want to know, what is your comment? What would be your comment on the provisions of Rule 64, Sub-Rule 2? Thank you, Mr. President.
Merci, honorable juge. À présent, honorable juge Adjé, vous avez la parole pour vos questions, s'il vous plaît.
To be centered on exhaustion of local remedies. I've gone through the Rwandan Constitution, and Chapter 4, that is from Articles 12 to 43, they are on personal rights. That is, only persons can exhaust, invoke and exhaust. Why do you expect Republic of Congo to go and make attempt to exhaust personal rights when they are personal to those who have suffered? Because they are not rights available to a country to exhaust within your own jurisdiction, because your own Articles 12 to 43, that is what they say. It is a personal right. So why do you expect a country to go there when you know that it cannot be exhausted? That is the first one. And the second one is that you referred to several European cases, but all the European cases, particularly Georgia versus Russia, I'm going slowly, Georgia versus Russia, 2011, European Court on Human Rights, application number 13255/07. It has been decided clearly that when we talk about admissibility, exhaustion of local remedy, we don't treat states, interstate, as individuals, because individuals are mandated to exhaust. But unlike states, where it is ineffective, unavailable, or even unfair, or the ground is not good, you cannot go and exhaust. So in this case, why are you expecting DR Congo to exhaust local remedies before invoking the jurisdiction of this court? And finally, if you look at the languages of the European Convention, that is the European Convention is on exhaustion of local remedy, is Article 35(1). Then Inter-American Convention, exhaustion of local remedy, is on Article 46. You will see that the language is quite different from what we have under Rule 50. What we have under Rule 50, particularly if you read Rule 50, sub-Rule E, which states that the court shall ascertain the admissibility of an application filed before it, that is, are sent after exhausting local remedies. If any, there is a provision in ours which is unique. The framers of the rules had in mind that circumstances may arise where individuals may not come, but a different body may come, where exhaustion of local remedy may not be a requirement. Why didn't you address and distinguish, if there is any? Thank you, Mr. President.
Merci à vous, honorable juge. Stella Anoukam, vous avez la parole, s'il vous plaît.
Come, you have the floor.
Of local remedy. But I have two questions. The first haven't already been asked by my colleague. And that question is to read to you a communication by the Banjul Commission and the ruling and the decision thereof. That is communication 227/99, DRC, Rwanda, and Uganda. And precisely the decision of May 20, 2003, paragraph 63, where the Commission concluded, and I read, that where the respondent state committed a violation of human rights on the territory of the applicant state, and I quote, local remedies do not exist, and the question of their exhaustion does not therefore arise. We will appreciate if you can distinguish this decision from your assertions, the assertions you have made and the submission you have made earlier. And my second question, Mr. President, goes to Our Lady, the lady who made a very copious submission on Rule 50D. That is, and I'll read, applications are not based exclusively on news disseminated through the mass media. And I wonder if you have looked at the claim by the applicant thoroughly. I have bothered to do so, and I found out that there are about 75 annexures. Will it be right to conclude that those annexures, the entire 75 annexures, all emanate from the media? And also bearing in mind that that requirement is that they are not based exclusively. We want you to address us on that. I think those would be the questions I have, Mr. President. Thank you.
Merci, Juge Anouka. Mon honorable Juge Chafika Ben-Saoula, vous avez la parole.
Justice Chafika. Thank you, Mr. President. I have two questions to the Respondent State. You considered that you linked your submissions to inadmissibility. You linked the abuse of process to inadmissibility, and I want you to explain how this link makes it inadmissible. And secondly, how you were able to say that all the evidence brought is from the mass media and therefore there's no evidence. I want you to just explain this. If what is contained in a document, for example, paragraph 92, when we make reference to the mediators, a communique that was made, all those, are they from the media source or do they emanate from a reliable source? Thank you. The court will now pose questions to the applicant state. Duncan, do you have any questions for the applicant state?
To access those local remedies within the territory of the respondent state. If you did, how? And what were the results? That's if at all you did. Two, just on the face of the pleadings, save for those matters which the respondents have pointed out that they are based on news disseminated through the mass media. On the face of the pleadings, can you briefly just point out any other source of your claim, any other source, if any? I'm asking this question to help you in mind with the submission that was made by Council Aboji. And the last question is the same question I've asked the respondents. What is your comment on Rule 64, Sub-Rule 2? Specifically, what is your comment on Rule 64, Sub-Rule 2? Thank you, Mr. President.
Merci, honorable juge Dankron. Honorable juge Dominique Adje.
Thank you, Mr. President. I will ask you only one question, and it is on legal issue. You address us on lease alibi pendants, and under the premise that there is a matter pending before the African court and another one pending before the European court, the East African Court of Justice. And if you look at our Rule 50, Sub-Rule G, it doesn't talk about when two cases are pending, but you spent much time on lease alibi pendants. So we were expecting you to address us on, if assuming one of them has been settled, then you talk about, you talk about res judicata. That is what the rule itself requires, and not lease alibi pendants. So why do you spend much time and not draw our attention to lease to res judicata under Rule 51G? Thank you, Mr. President.
Merci à vous. Honorable juge Anoukam.
Merci, Mr. President. Just still on this issue of Rule 50G regarding the applicants. Agreed, you were able to convince us that we do not have the concurrent jurisdiction with the East African Court of Justice. But in your presentation, you tried to explain that even when there is a pending application before the East African Court of Justice, what is important to note is that the parties are not the same, the subjects are not the same, and they do not have identical facts. And then my question is, in what name is the application before the East African Court of Justice? Are the parties same or are they not same? And moreover, what level is the application as at today? What stage is it as at today? Because your colleague, the Respondent State, had raised the issue of having a stay of proceeding. Would like to know what stage it is today. Thank you.
Merci, Monsieur le Président. Je vais rester un peu dans la question. Still, in line with my colleague Stella's question, I would like to ask something. In the file, we refer to two decisions. One is the African Court, another one. With the permission of the President, I would like to have the copy of this application, before the East African Court, so that I have all the details on the merits and what is required and so on and so forth. We really absolutely need this document. We cannot refer to what you are going to say. We need to have the application to be sure that these are not the same applications, not the same parties, and so on and so forth. I have another question to ask to the applicant. You talked about a continuous violation when we were talking about the admissibility. Could you relate both? Are the continuous violation part of inadmissibility? Why have you related both issues? How continuous violation relates to the internal remedies? Thank you, Mr. President. Justices, for your questions. For you to prepare your answers, which will be submitted to the court. Regarding to the pleadings and the documents requested by the court, you have a deadline of 8 days from today till next Thursday to send them to the court. You have the floor, Respondent State.
Maître, il aurait été bien que vous nous disiez.
We'd like to know exactly what you need, as long as you think that the time limit is not enough, that is to say 15 minutes. What is your proposal? How long do you need?